Hi, I'm David Soble, and I'm a Michigan real estate and finance attorney. Today we're answering a question from a homeowner in Clarkston, Michigan concerning a mortgage dispute that he has. He's seeking a mortgage resolution to his problem. And he writes into us and he says, I've received a call from a new mortgage company stating that my mortgage now is owned by them. It is for an old second mortgage that I have not paid on in over 8 years. This is because several of my earlier payments were returned to me in 2012, and the old company never responded to my inquiries. I never heard from them afterwards. And I've had several other mortgage companies who claim that they own the mortgage. They've written to me and they call me, but they never follow up when I inquire into my payment history. This new mortgage company, however, has sent a response and has threatened to begin a lawsuit against me, yet nothing legal has happened at this time. And he writes, or he asks, how should I respond to this mortgage company? Well, it's a great question. First, you should know that even if the former mortgage company or former mortgage companies in the past have not responded, the mortgage that you have most certainly encumbers your property. So the old mortgage is still on your property. So at some point, if you go to refinance or you go to sell the home, you're going to need to contact the appropriate lender for a mortgage discharge. So it's really important that you get this resolved. So when there's confusion in my world, when a client comes to me with this issue, when there's confusion as to what happened to their mortgage or who has the right to collect on a mortgage, I always request that the purported mortgage company verifies or validates how they have come to own the rights to collect under the mortgage. And this is usually verified by filing, looking at mortgage assignments from one lender to another. So once we send out a demand letter asking for verification, the mortgage company or the lender will send back proof by showing their assignments. And that's really where you want to start. And once you get the proper response and the documents from the mortgage company proving how they actually own or how they have the rights to service the mortgage, then I actually ask for what we call an accounting. And that really is to determine how much has been paid into the mortgage since its inception, and also to determine how much is going to be needed to pay off or reinstate payments under a mortgage that hasn't been paid on for a while. And it's very likely that this company who's bought the mortgage at your current mortgage at this time, they've done it at a deep discount. And so they're looking for a high rate of return for their investment, especially in this, what people would consider this very prosperous economy where home values have increased and equity positions have improved. Finally, you're going to want to seek the counsel of a qualified real estate or mortgage attorney. Usually they go hand in hand. And you may feel, capable on your own to negotiate payment terms, but really that's just the half of it. You're going to need to generate the best forbearance terms or best forbearance documentation that memorializes your agreement between you and this new lender. And without an attorney, you will most likely miss the little tricks that lenders can play, and that actually may worsen, not improve your position. You have to remember, lenders and banks have their own attorneys who draft their documents. And if you don't have your own attorney, you're going to be at a serious disadvantage. So trust me on this. Half of every week of my work week is cleaning up from what I call from others people's legal vomit. I'm always correcting or supporting basically bad documentation that people entered into on their own. For me, it's good. For the clients, unfortunately, it's bad. So I'm David Soble. I'm a Michigan real estate attorney, and I can be reached at provenresource.com. And you can also reach me at 888-789-1715. Thanks for watching.